online defamation. Basically, online defamation is when someone makes a false statement about you in terms of verbally or in writing that could cause damage to your reputation. To put aside, over hundreds years ago, courts have attempted to balance one person's freedom of expression against another person's rights to defend their reputation. Plus, the internet have enabled more free speech than ever before, as well as the opportunity to denigrate someone's character through a post or comments. Plus, more specifically, online defamation could arise from various aspects such as Facebook, Instagram, TikTok, Twitter, and many more. Last but not least, as for an example, we can see that from both larger or smaller business may suffer from posts that with content, malicious intent, such as that leads to purposely harm someone's reputation or career.
There are three elements to be fulfilled for defamation. The first one is the word are defamatory, the second one is the word are referred to the plaintiff, and lastly that the word has been published. For the word are defamatory, their requirement is satisfied when they have tendency to lower the word estimation of the plaintiff in the mind of right-thinking member of society, so that the plaintiff is avoided, shunned, or ridiculed. The second element is word must refer to the plaintiff. If the defendant intends to and refer to the plaintiff by name, it certainly satisfies the above requirement, even if a plaintiff is not specifically named in the word, he may describe so as to be recognized. Third element of defamation is the word must be published. Publication is the communication of the word to at least one person other than the person defamed. Where the communication is to the plaintiff himself, there is no publication because defamation is an injury to one's reputation. No one's own feeling, and reputation is what other people think of a man and not his own opinion or himself.
Assalamualaikum warahmatullahi taala wabarakatuh. Next, there are two parts of defamation. First, slander, and second, libel. For libel, elements that need to be satisfied are defamatory statement. It was made or conveyed by written or printed words or in some other permanent form such as newspaper. Defamatory statement concerns the plaintiff and it is published to a person other than the plaintiff. For defamation in a permanent form, it's usually visible to the eye, such as item in writing which includes email, pictures, SMS, status, or effigies. Section 3 of the Defamation Act provides that the broadcasting of words by means of radio communication shall be treated as publication in a permanent form and therefore constitute as libel. Libel is actionable per se. For example, you belong to the neighborhood committee. You get a message on WhatsApp from a group that includes many of your neighbors accusing you of being a troublemaker and dishonest person. Next, for slander, the following elements need to be fulfilled. First, there is a defamatory statement made or conveyed by spoken word, sound, or in some other non-permanent form. Next, the defamatory statement concerns the plaintiff. Then, the defamatory statement is published to a person other than the plaintiff. Publication is usually made through spoken words or gesture. A slander is not actionable per se. For example, in an event attended by many of your colleagues, someone loudly exclaims that you are a lazy and incompetent worker. This person also said that you are only in your current position due to certain favors provided to your supervisors. Next, spreading false rumors that a restaurant is serving meat from dogs, which would cause potential customers to avoid the restaurant. Additionally, for slander to be actionable per se, generally a person is required to prove that he or she suffered actual damage or special damage. A person will have to show that he or she suffered pecuniary loss or loss that is capable of being estimated in money directly due to the slanderous remarks made against him or her.
Assalamualaikum. I'm Sarah Safia Anur. My matrix number is 071346. Today I'll be presenting about how to deal with online defamation. Firstly, get the defamation statement deleted. Try contacting the publisher or user directly and explain your problems with the article in question with an email. Tell the author of the defamatory content that they have made an error in their statement. Give the correct information and explain that the continued publication of the invalid comments will hurt you financially. Secondly, ignore the defaming statement. By not making any public response, it will help you to avoid drawing more attention and makes the defamer look unreliable who accuses others. Besides that, hire a reputation management company. An experienced online defamation attorney will make sure that you are handling the situation appropriately. Not only that, if you know the defamer, the online reputation specialist may advise you to send the person a demand letter to get them remove the defamatory content that has been posted, otherwise you will file a lawsuit. Lastly, take a legal action. But before that, make sure that you keep all records of the defaming statement made towards you. Take screenshots of the posts or comments, search engine results to preserve the evidence. You should also hold on to any evidence that indicates the defamer's identity.
The example of the online defamation in UK is the case of Stanley K. Young and New Haven Advocate. Stanley K. Young is the prison guard, and New Haven Advocate is a publisher of online newspaper. On 30 March 2000, the Advocate published a news article written by the defendant Camille Jackson. It's about the transfer of Connecticut inmate to Wheeler Ridge. It discussed about alleged harsh conditions at Virginia prison and point out about the long trip to southwestern Virginia made by prisoners' family difficult or impossible. Around at the same time, the Courant published 3 columns written by the Army Pagnozzi. It's questioning the practice of relocating Connecticut inmate to Virginia prison. The column report on letter written home by inmate who alleged cruelly by prison guard. In one column, Pagnozzi called Wheeler Ridge a cut red color. Name of Warden Young was not mentioned in any of the Pagnozzi column. Young claimed the article implied that he is racist who advocates racism and that he encouraged abuse inmate by the guard. Young argued that personal jurisdiction is proper in Virginia because the newspaper understood that their defamatory articles, which were available to Virginia residents on the internet, it would expose Young to people's hatred, contempt, and ridicule in Virginia, where he lived and worked.
To continue the case, the district court ruled the defendants were all well aware of the fact that the plaintiff was employed as a warden within the Virginia correctional system and resided in Virginia, and they also should have been aware that any harm suffered by Young from circulation of these articles on the internet would primarily occur in Virginia. The fact that the newspaper's websites could be accessed anywhere, including Virginia. However, they did not aim for Virginia audience based on the websites of the Courant. citynow.com provide access to local, Connecticut weather and traffic information. The websites of the Advocate show stories focusing on New Haven. Therefore, the court reversed the order of the district court, denying the motions to dismiss for lack of personal jurisdiction made by the New Haven Advocate, Gil Thompson as the editor, Camille Jackson, the reporter, and by the Hartford Courant, Brian Toole, also the editor, and Amy Pagnozzi as the reporter. Because the newspapers did not intentionally direct internet activity in Virginia, and jurisdictions falls on the ground would file a lawsuit.
In the case of Godfrey Demon Internet 1999, the plaintiff is Lawrence Godfrey and the defendant is Demon Internet Ltd, owner of the Usenet News. On 17 January, Godfrey informed Demon Ltd that the posting was a forgery and asked it to remove the posting from its Usenet News server. Although it was within Demon Ltd's request, it failed to do so, and the posting remained available on the server until its expiry on or about 27 January. Godfrey subsequently brought proceedings for libel against Demon Ltd in respect of the period after 17 January 1997. The plaintiff sued defendant for defamation due to the posting forgery and defamatory on Usenet News server. Accordingly, it ruled that the company did not have a viable defense under Section 1 of the Defamation Act. In conclusion, according to the court's ruling, the defendant published the defamatory posting and as of 17 January 1997, it was aware of the posting's offensive nature. As a result, the defendant is ineligible for protection under Section 1 of the Defamation Act 1996, and its Section 1 defense is legally hopeless. In a nutshell, online defamation is an offence committed because of an untrue spoken or written expression referring to a person that when published is deemed harmful or likely to harm an individual's reputation. Online defamation is a type of offence that could be considered even more serious since sharing and spreading insult through the web is all too easy. Those who feel vilified usually take no pleasure in having their reputation tarnished by false and negative information.